Another day, another solution. Let's talk dirt. A couple of years ago, I litigated a tree dispute between two adjacent property owners. Now, this tree was not a shrub, it wasn't a sapling. It was a massive 75 to 100-year-old oak tree. The tree was also historic and it was very popular within the neighborhood. The canopy to the tree stretched 50, maybe 70 feet across, and it dominated both properties. But most importantly, it sat right on the boundary between the two properties, literally almost half and half on each property. Now, my client's neighbor had just purchased the adjoining property, and he had bought it for commercial development purposes. Despite our client's clear objections, the neighbor cut the tree down. Now, this case taught us something important. Texas law on boundary trees is anything but settled. A boundary tree is typically a tree whose trunk straddles the property line between parcels. In other words, it's half on one side, half on the other. And that distinction matters in law far more than most people realize. Because branches do not decide ownership of the tree. The roots do not decide ownership of the tree. The trunk is actually what decides the ownership. If the trunk is entirely on one side of the line, even by a small margin, most courts treat the tree as belonging to that owner. But when the trunk itself sits on both properties, legal uncertainty begins immediately. Most people assume that the rule regarding boundary trees is simple and intuitive. It's on my land, so why can't I cut it? Well, it's not that simple. Now, in some states, that is partially correct. In others, that would be completely wrong. Across the country, courts take very different approaches to boundary tree disputes. Some courts treat boundary trees as jointly owned property. Others focus on who planted the tree originally. Some ask whether the tree was intended to mark a boundary, and others analyze nuisance, equity, or even trespass principles. In other words, there is no nationwide rule that prevails, and Texas has not clearly chosen one either. Now, here's the reality in Texas. Appellate courts have barely addressed the boundary tree disputes over the last 100 years. There are maybe 3 to 5 reported cases across the entire state that we found when we were dealing with this issue. None of the cases provided a bright line rule or a universal test. So as a result, trial courts are often left to weigh facts and make their own decisions. Property boundaries, intent and conduct, equitable principles, trespass, damages. Sometimes courts can even look to how other states have handled similar disputes. That makes outcomes in Texas highly fact specific. So in our case, the tree clearly sat on the boundary line. This case was not about trimming, it was not about routine maintenance. This was about the destruction of a historic oak tree, and it was done over our client's objections. We argued to the court that because the tree sat directly on the boundary, in other words, on both properties, that it was jointly owned. In other words, neither property owner had the unilateral right to destroy it without the other's consent. After a bench trial, the court agreed with us, agreed with my client. The neighbor had committed a trespass and they were found liable for monetary damages. Now, in our case, the result turned on facts, location, lack of consent, and so it was not a simple legal rule. So here is the key takeaway. If a tree truly sits on a property boundary, do not treat it as 100% your own. And here's the caution people often overlook. For some people, trees mean absolutely nothing. And for others, they mean absolutely everything. So just because you're not emotionally attached to a tree does not mean your neighbor is not. If you cut down the wrong tree, you can easily find yourself in a $50,000 legal fight you simply cannot walk away from. At a minimum, get a professional survey, talk to your neighbor first, document objections or consent, and slow the process down. Remember this, once a mature tree is gone, You don't get a do-over. It's not easy to replace a tree of 50 to 100 years old. So here's what I want you to remember about this video. Boundary tree disputes are rarely just about the trees themselves. They are about expectations, property rights, and emotions running high. If a tree sits on a property boundary, do not assume ownership. Do not assume permission. Do not assume common sense will protect you later. Cutting first and asking questions later is how lawsuits start. If your neighbor cares and you destroy that tree, you may face trespass liability and serious monetary damages. As you've heard, I've seen cases turn into $50,000 fights that no one planned for, all because someone thought it's just a tree. If this video helped you, hit like and subscribe to the channel. Remember, this is your channel where we keep an ongoing conversation about relevant Texas issues in real estate law. If you need legal help beyond this video, visit our website linked in the comments below. You can also drop your questions or scenarios in the comments. As always, thanks for watching.